Hi everyone, in this week's dispatch video we are discussing flexible working in action, so a case which has reached the Employment Appeals Tribunal, and this concerns community nurses who were required to work flexibly, including at weekends. The employee who brought the claim was a mother of a child who was had significant disabilities, and her position was that because of her caring responsibilities for the child, she couldn't work weekends at all. Now, the claim that was brought was for indirect sex discrimination under the Equality Act. So this indirect discrimination applies where there is a provision, criterion or practice put in place, in this case the requirement to work flexibly at weekends, which puts this particular employee and others who share their protected characteristic at a particular disadvantage. So what the employee was suggesting in this case was that because female employees have primary carer responsibility for children, statistically in most cases, that group was being placed at a disadvantage by virtue of the requirement to work weekends. Now, this is an interesting case in action because it essentially looks at the defence that the employer has available to such a claim, and that is essentially the defence of justification. Is the PCP, the provision that requires weekend working, a proportionate means of achieving the NHS Trust's legitimate aim of providing care in the community on a 24/7 basis, balancing the workload among the team and reducing the pressure on more senior nurses at the weekend? So the Trust in this case argued that there was significant difficulty caused by the refusal to work at weekends. This employee never worked public holidays or weekends, so other staff had to cover. They didn't have a particularly strong headcount, but that meant there was significant operational difficulties and reliance on other members of staff, which was not fair. Now, the tribunal originally held that the principles of work-life balance and flexible working were reasonable and widely accepted in the circumstances, that had to be balanced against the employer's own needs. And in this case, the particular pattern that the employer was demanding would lead to problems with delivery of the service and relationships between colleagues. So the tribunal said, unfortunately for the employee, the employer was justified in turning down the flexible working request. There was also no other suggestion raised by the employee about an alternative working pattern or ways in which the Trust could achieve those aims. She appealed to the Employment Appeals Tribunal, and they concluded the same, that the arguments on justification were finally balanced, but ultimately they came down in favour of the needs of the employer to have a pool of flexible staff from which to operate a 24/7 service. So the case highlights that refusing a flexible working request can often lead to significant consequences in terms of claims activity, particularly in indirect discrimination claims. It's absolutely vital when considering reasons for rejection that there is significant reasoning provided for that, which not only meets the statutory grounds for refusal, but also looks behind that at the precise justification. The organisation should also consider alternatives to rejecting that. So were there any other measures that could have achieved their aims? In this case, it was determined that there weren't. And providing as much evidence to support those conclusions as possible is crucial in the circumstances. If you do need any further advice on flexible working applications or anything relating to employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.